Good afternoon, everyone. Welcome, and thank you for joining us for a celebration and discussion of this important new book, Hidden Histories of Unauthorized Migrations from Europe to the United States, edited by Debbie Kang and Danielle Battisti. My name is Lana Barber, and I'm the director of the Immigration History Research Center here at the University of Minnesota. I'm relatively new to the IHRC, but the center itself is not new. In fact, the IHRC is celebrating its 60th anniversary this year. For more than half a century, the IHRC has been promoting knowledge and understanding about immigrant experiences. We regularly host events online and in person that are free and open to the public. If you're not already subscribed to our newsletter, please do sign up so we can let you know about future programming. I'd like to thank our co-sponsor for this event, the Department of History here at the University of Minnesota, as well as Michelle Waslin and the Institute for Global Studies events team for their work making this event possible. I'd also like to acknowledge that the University of Minnesota Twin Cities is located on Dakota land. The Twin Cities remain home to many Indigenous people, including Dakota and Ojibwe from throughout the state. The IHRC acknowledges that the migration of immigrants and refugees to the United States has been part of settler colonial practices that displace and dispossess Indigenous peoples. The study of immigration must reckon with these intersections, consequences, and legacies. Before we get started, I wanted to highlight a few housekeeping items. This webinar is being recorded. We'll have a question and answer period later in the event, and I encourage you to submit questions at any time using the Q&A function on Zoom. You can choose to submit your question anonymously if that's your preference. We're fortunate to have with us today both the editors of Hidden Histories of Unauthorized Migrations from Europe to the United States, as well as a couple of the contributors to this powerful edited volume. We're going to begin by hearing from the editors, Debbie Kang and Danielle Battisti, who will give us an overview of the entire book so you can have a sense of the project as a whole and why it's such a powerful intervention. And then we'll hear from each of the panelists about the history they cover in their own individual chapters. I'll give brief introductions to everyone here at the beginning so I don't interrupt the flow of their presentations. So first, the editors include S. Deborah Kang, who is an associate professor of history, and the John L. Now III Associate Professor of the History and Principles of Democracy at the University of Virginia. Her research and writing focus on the historical and contemporary aspects of U.S. immigration law enforcement. She has also served as a consultant to federal public defenders throughout the country who have been challenging the constitutionality of the laws criminalizing immigration. For this work, she recently received the inaugural OAH Award for contributions to public policy. Danielle Battisti is Associate Professor of History at the University of Nebraska at Omaha, where she specializes in immigration and ethnic history. Her book, Whom We Shall Welcome, Italian Americans and Immigration Reform from Fordham University Press in 2019, was awarded the Immigration Ethnic History Society's Best First Book Award for 2019. Dr. Battisti has also published articles and chapters in the Journal of American Ethnic History, the Italian American Review, Making Italian America, Consumer Culture and the Production of Ethnic Identities, and Ethnic Families in America. Next are two presenters who are not also editors. We have Carly Goodman, who is an assistant professor in the Department of History at Rutgers University, Camden. Her book, Dreamland, America's Immigration Lottery in an Age of Restriction from UNC Press in 2023, won on the U.S. Diversity Visa Lottery, received 2 awards. She serves as senior editor of Made by History at Time Magazine, which was formerly at the Washington Post. Torsten Feest works as a researcher at Flanders Marine Institute and as a guest professor at the University of Antwerp. He conducts research on migration, tourism, and maritime history. One of his 3 major research areas assessed how shipping companies commercialized transatlantic migrant transport and became entangled in enacting, enforcing, and invading migration laws. So I'm just able to give you a short introduction, a short biography of each of our presenters, but I encourage you to look them up, to reach out if your research intersects with theirs. All right, so enough from me. I'd like to turn this over to Debbie Kang and Danielle Battisti, the two editors of this fantastic volume, to give an introduction to the book as a whole.
Thank you so much. Okay. Thank you so much, Lana, for that introduction and for hosting us. And thank you all for attending. We all know how precious our time is. So with that note, let me get this slideshow going. And going to take about 5 minutes, sort of introducing you to the collection, and I think Debbie is going to as well. So of the title of the anthology, Hidden Histories of Unauthorized Migrations from Europe to the U.S. Put that up on the screen along with the table of contents. Our project is bringing together two discussions about two topics that don't always get connected, at least in public discourse or national mythology. And that is, of course, the subjects of unauthorized migration to the United States and narratives about European immigration. And for the sake of time, to sort of illustrate this point, I'll start by talking about a figure, a place that probably many of us on this call are familiar with, and that is Rosaria Baldizzi, an Italian immigrant who came to the United States in 1923 and whose family story is featured as one of the Lower East Side Tenement Museum's reconstructed apartments. Since its opening in 1988, millions of visitors have gone to the Tenement Museum or places like it that might tell similar stories, Ellis Island, for example. And at those sites, visitors take in major narratives about immigrant experiences in the U.S., the nation's history of welcoming and or excluding certain newcomers, and think about processes like assimilation, acculturation, and so forth. But about a decade ago, the Tenement Museum updated the way that they presented Rosaria's story. Both the museum's in-person and virtual exhibits now present a more nuanced retelling of her history, one that now incorporates her status as a migrant who entered into the country without a visa. Her subsequent petition to adjust her status and stay in the United States is included in her narrative, and the government's normalization of her legal status and granting of her citizenship in 1948 is also a public feature. Interestingly enough, these changes came as the museum made updates, not because they suddenly discovered new archival material, but because they were guided by shifts in the scholarship about irregular pathways of migration. The fact of the matter is that Rosaria's story is much more common than we typically acknowledge. Recent scholarship, including work by May Nye, Ashley Johnson Bavery, Libby Garland, Brianna Knofel, just to name a couple, point out that European migration to the US that occurred outside of the law has a long history, that European immigrants evaded US immigration laws in diverse ways, and we try to highlight some of those in the anthology. We have not been exhaustive, and that they did so in greater numbers than we've previously sort of acknowledged. In fact, when we've presented on this material along the way to producing the book, we were often approached after conferences by audience members who, would recount things like family histories of clandestine migrations or had recollections of dealing with immigration lawyers and so forth. So our collection aims to flesh out narratives of unauthorized European immigrants, and in telling these stories, we also find some overarching trends about why these histories have remained hidden or obscured from view for so long. In the collection, we discuss how the erasure of these subjects has been linked to racialized concepts of legality and illegality that arose with settler colonial legal and social constructions, and that have carried on through various processes long thereafter, even up until this day. These processes have impacted the public and the state's relatively permissive attitude toward unauthorized white migrants when we compare their experience with their non-white counterparts. So in the anthology, we discuss how even while unauthorized European migrants may have periodically been recognized as a phenomenon and considered problematic by certain groups in the United States, in many cases they were willfully ignored, erased, forgiven, or reclassified as relatives, refugees, asylum seekers, others by the public and by the state. Um, we, in the anthology, try to take a look at how prosecutorial discretion in enforcement of the nation's immigration laws impacted and often benefited our subjects. We discuss how the government made pathways to legalization available for some illegal aliens and not others. And we examine how claims to whiteness often afforded European migrants more freedom of movement at borders or ports of entry, at workplaces, detention sites, than their counterparts from elsewhere in the world. So Debbie will speak on this a little bit more, but combined, we see these histories telling a story of how European migrants continued to be depicted in public discourse and sometimes even our teaching or scholarship as, quote, normal immigrants against which others have been compared. Um, Debbie, I will stop sharing unless you want me to keep the slideshow up.
Can you return it to the table of contents?
Oh, is it not there?
Oh, yes, it's okay.
Okay.
I'm looking at the wrong slide. Okay. So I'm just going to briefly discuss the logistics surrounding the production of the book and the ways in which we hope that all of you will employ the book in your classrooms and in your own research. So when we issued the call for papers for this project in 2020, our goal wasn't to create a comprehensive history of unauthorized European migrations to the United States. And in fact, we believe that a lot more work needs to be done on this topic, and we have some suggestions in the volume for further directions on this issue. But instead, when we issued the CFP, our goal was to get a sense of the scholarship or the research that folks in the United States and abroad were doing on this topic. And we also wanted to get a sense of the methodologies that different scholars were using. And so what's resulted is a really, what we think is a very rich and interdisciplinary volume. So we have contributions from historians and sociologists from the United States and Europe who have been doing some really interesting work on the topic of unauthorized migrations from Europe to the US. And what we decided to do with the contributions was to organize them in a kind of layered fashion as to one that was chronological and one that might lead the reader to believe that, mistakenly believe that we were trying to create a total or a comprehensive narrative, which we are not. So the first three chapters really give the readers a sense of the domestic legal architecture that created both European illegality as well as erased it. And then the second section looks at how issues such as race, gender, class, disability, and conceptions of respectability mediated the experience of illegality on the ground for these European migrants. And then the final section is a reminder that the production of illegality as well as legality are global processes. They're often processes that begin abroad. And then the introduction we wrote as we envisioned the introduction as complementing each one of these chapters, and the introduction provides an explanation as to why the historiography to date, that is why historians in the past really haven't, except for the ones that Danielle has mentioned, haven't done more work on this issue of European illegality. And then the introduction also provides a narrative of how it is that domestic US laws generated the figure of the unauthorized European immigrant, as well as created the mechanisms for the erasure of European illegality. So, Danielle, do you want to add anything to that? No. Okay. So I think with that, we can go ahead and start the presentations. Do I need to turn things back to Lana or no? Okay, so then with that, I think that I will be presenting my own contribution to the volume. Give me a second. Okay. All right. Okay, so all right, so my contribution to the volume is a history of this group of individuals known as the White Russians, and it's an account of how special legislation was created to legalize the unauthorized status, again, of these so-called White Russians. So in 1934, so in 1934, the Immigration and Naturalization Service adjusted the immigration status of Nicholas Kravitsky, Percy Walensky, and Aksinia Dorofieva Timofeyev. At various points in the 1920s, the three had entered the United States in violation of its immigration laws. Kravitsky had deserted his position as a crewman on the SS Polonia. Walensky had crossed the US-Canadian border without an official immigration inspection, and Timofeyev testified that she had evaded inspection by mingling with a big crowd when crossing the line in San Ysidro. The three were only a few of the nearly 2,000 unauthorized Russian immigrants who benefited from a federal immigration legalization statute, the Act of June 8, 1934, that halted their deportations, adjusted their immigration status, and gave them a pathway to U.S. citizenship. Based on the 2000 case files of the so-called White Russians legalized under the 1934 law, this chapter of Hidden Histories narrates a forgotten moment in the history of illegal alienage. I specifically describe how policymakers managed to save the White Russians from being deported to the Soviet Union during the Great Depression. While the White Russians had been defined as refugees under international law and perceived as such by the American public, policymakers were reluctant to create a domestic refugee measure on their behalf that would have enabled them to remain in the United States. Due to the rampant anti-Semitism and xenophobia of the Depression era, the Russian supporters knew that any effort to pass a refugee bill for them would fail. In this context, advocates recognized that the Russians' rescue required a different approach. As a result, they made the tactical decision to downplay the Russians' identity as refugees, underscore their status as undocumented immigrants, and lobby for their legalization. More broadly, this essay, along with the chapters prepared by my fellow contributors to Hidden Histories, illustrates how bureaucrats and policymakers eased the social and legal burdens of illegality for European migrants, while they simultaneously reinforced those same burdens for unauthorized Asian, African, and Latinx migrants. Indeed, as policymakers worked to legalize the White Russians, they facilitated the forced repatriation of nearly 500,000 ethnic Mexicans. As a transnational history, my chapter traces the paths of the Russians from the Soviet Union to the United States in the 1920s. The first section traces how the White Russians came to be defined as refugees under international law. Indeed, their plight laid the groundwork for the creation of an international refugee law regime. Meanwhile, the last section of my chapter recounts the congressional debates that led to the passage of the Act of June 8, 1934. But for the sake of time, I'm going to zero in on the middle sections of my chapter, and I'll briefly describe the experience of the White Russians in the United States, and then I'll move on to an overview of the broader arguments that were used to justify their legalization. So, due to their legal status as refugees, Russians were able to settle throughout Europe. Nevertheless, many Russian refugees saw America as a quote-unquote promised land. Impatient with the impossibly long wait list created by the 1924 National Origins Quota System, many of the refugees elected to enter the United States without authorization. Once they arrived, the Russians were spared from deportation because the United States did not recognize the Soviet Union. Since they were relatively unhindered by interior immigration enforcement, the Russian refugees managed to rebuild their lives in the United States. By 1934, they appeared no different from middle-class Americans, and indeed they fared better than the average American during the Great Depression. As I explain more fully in my chapter, the Russians achieved not only a certain degree of structural integration, they were also accepted for ideological reasons. As a result of the Russians' staunch anti-communism, Americans represented them as ideal prospective citizens and often contrasted them with so-called Reds, or those Russians with communist sympathies. Yet, as the United States and Soviet Union commenced diplomatic relations, white Russian communities panicked, recognizing that this event made possible their deportation to Russia. In response, immigration advocacy organizations and sympathetic policymakers came to their aid and worked to block their expulsions from the United States. In defending the Russians, their advocates, however, were careful to stress their identity as unauthorized migrants rather than refugees. Again, due to the widespread xenophobia of the 1930s and the long-standing reluctance to formalize an American refugee policy, advocates knew that any attempt to pass a Russian refugee law would trigger tremendous opposition from congressional restrictionists. Thus, as states and localities deported thousands of undocumented Mexican immigrants, policymakers constructed a sympathetic portrait of unauthorized European migrants that would later inform the passage of the 1934 law. More specifically, in 1933, the INS and the Department of Labor created the so-called Ellis Island Committee and charged it with conducting a study of immigration law enforcement. Published in 1934 as the Ellis Island Committee report, it softened conceptions of European illegality. The report specifically described unauthorized entry as a benign infraction. By way of explanation, the report argued that illicit entry was often the product of an administrative error rather than any ill intent. So, for example, the committee observed that for decades along the Canadian border, INS officials failed to keep thorough admission records. As a result, as the report wrote, aliens who entered at such points during these years have suffered consequently through no fault of their own, but as a result of the negligence of the government. When illegal entry was the result of human error, the Commission argued that often immigrants simply didn't know that they were violating the immigration laws, especially given their complexity and especially since they had changed several times over the course of the 1920s. So in sum, from the perspective of the Ellis Island Committee, illegal immigration bore none of the hallmarks of crime, but rather administrative error and ordinary human ignorance. As I discuss in further detail in my chapter, the committee went on to recommend the expansion of an adjustment of status measure popularly known as the Registry Act of 1929. As Danielle explains in her chapter, the Registry Act barred from legalization those racially ineligible to citizenship. Yet the Ellis Island Committee remained silent about the racism that underwrote the registry law. Instead, the committee facilitated its reproduction by proposing the extension of the 1929 Act to European refugees, including stateless persons like the Russians. Without this modification, the Russians would be deported to the Soviet Union, where they would face persecution and even death. As the Washington Post explained in a piece about the Ellis Island Committee, immigration relief for the Russian refugees was essential because, quote, upon no class of immigrant perhaps has the mailed fist of deportation law fallen harder than it has upon the white Russian, unquote. So, a few short months after the publication of the Ellis Island Report, Congress passed the Act of June 8, 1934, which legalized the status of undocumented Russian refugees. To conclude, policymakers' strenuous defense of undocumented Russian immigrants exposes the profound contingencies surrounding the conceptions and treatment of undocumented immigrants. The experience of the Russian refugees serves as an important illustration of how the boundary between illegal and legal status was fluid rather than fixed, making it possible for undocumented immigrants to become documented. Their history also exposes the variety of meanings ascribed to illegality and how those meanings were dependent on arbitrary social criteria such as race, gender, and ideology. And perhaps most important of all, the legalization of the white Russians highlights the sharp contrast in the treatment of undocumented European and undocumented Mexican immigrants during the Great Depression. As the nation's immigration laws criminalized Mexican illegality, they simultaneously erased and normalized the irregular migration pathways of the white Russians. Thank you.
Okay. I am going to take a moment and try to share my slideshow properly this time, which apparently I didn't before. So, um, all right. Um, so my contribution to our volume, am I still showing the previous slide?
Yes, you're not showing the presentation view. We're able to see your view. So we're seeing the your notes and the next slide that's coming up, unfortunately.
Then
Danielle,
I
would you like
may,
me to share?
yes, that would be great. Thank you. Okay. So then, I'll just start by talking about my contribution to our volume, which features a case study. Starting on slide 4 would be great. A case study, and we can advance to slide 5 actually, of Italian merchant seamen who entered the United States legally with temporary commercial non-immigrant visas. These are D1 visas that are issued to crew members of marine or air vessels. It allows members of the crew to stay in the country up to 30 days while they're performing job-related sort of activities. And the men in the study enter into the country into the 1950s, and they become unauthorized migrants when they chose to jump ship, to use, sort of everyday parlance, and overstay those visas in order to live and work in the United States. The data set that I use for this chapter comes from research at the Italian that I did with records from the Italian Welfare League. This is a New York-based immigrant aid organization that was operating since the 1920s, and among the many services that it provided to Italian immigrants, it included pro bono legal services. And I first came upon this collection when working on my dissertation or first book. And I was interested in refugee cases at the time. I didn't quite know what I had on my hands, but even then I knew that there was something going on because there seemed to be a whole lot of cases featuring migrants that the IWL was labeling seaman deserters. Maybe we could have the next slide. Later, when I finally looked back at all of the IWO case files from 1950 to 1960, and there's many more, I did this as a sampling. Maybe if we have time in Q&A, we could talk about why. I looked at just over 600 cases in all that spanned this decade, and I discovered about half of them involved unauthorized migrants. And of those half of cases, seamen deserters or ship jumpers made up the vast majority of those cases. And these files are extremely rich. I think you can see that just by looking at the intake dossier that you see here that the IWL asked for. It has all of this rich demographic material, things like passport photos, documentation of entry. Many of the case files have court transcripts, warrants of arrest, hearing dates, correspondence, forms for adjusting status. And if you get one of those, you usually get residential and work histories, bank statements, affidavits of support. So the Excel sheet I have for this this study is like, oh my gosh, 200 cells long. And I am hoping that there's going to be some digital mapping, digital projects that come out of this. If there are any eager grad students in the audience or other collaborators. Anyway, this data allowed me to paint a picture of trends in unauthorized Italian migration that were occurring in the post-war period. And it showed a couple of things. First, the ubiquity of the practice, right? That we have Italian migrants who came to the organization for help, and about half of them had unauthorized legal status. Secondly, it showed that at least among working class Italian men, and I derived that they're working class from that economic data, work history, and the fact that they're seeking pro bono legal support, that the overstaying on this D1 visa had become a very popular method for irregular entry. And we have evidence of this happening since the 1920s. We know this from existing scholarship. We know this from INS reports, congressional legislation, comments from immigration officials, some of which Debbie spoke about a little bit earlier. And then the other thing that I find from this data and what occupies the bulk of the chapter is the fact that the INS, while it periodically focuses on ship jumpers as a problem, and we could go to the next slide, and there are sort of episodic enforcement shifts or shifts in enforcement where we'll see crackdowns on the practice of trying to catch ship jumpers. On the whole, what the data is showing us is that the state is relatively permissive when it comes to the seamen deserters, at the Italian seamen deserters at least, and that we see this kind of reflected in public attitudes as well. In fact, when we take a look at what's going on in the IWL records, the cohort of migrants that I have here did not face extreme economic hardship resulting from arrests for immigration violations. The men in my case files were rarely detained for extended periods of time, and they generally secured positive legal outcomes in their quest to remain in the US and adjust their status to legal permanent resident alien and ultimately obtain citizenship. So if we can go to the next slide, I'll just talk about some of the conclusions that I find. If we take a look at these records, if an Italian seaman deserter had managed to marry an American citizen and produce at least one American-born child with her before he was arrested and ordered deported, in 97.5% of the cases, his appeal of deportation was successful. I'm sorry, I misspoke. If at any point in the proceedings he had children, it didn't have to happen before arrest. There are other cases where men are only married, they don't have children with their American citizen wife. In 87% of the cases, these men are allowed to adjust their status, which means at some point after they have been ordered deported or they have been allowed a voluntary departure, that they appeal that order. They go through the Board of Immigration Appeals process. Sometimes it can happen after one appeal. Sometimes these processes can take years. But if at any point they are married, they have children, these are the kinds of adjustments of status that we see. The other thing that we see that I think is really striking is that only a little bit more than a third, about 40% of the men that show up in these case files started out as married. So at some point in their proceedings, about a little less than 2/3 of them will go out and get married. That could be a day after they were arrested. That could be weeks. It could be a year into the process. It really varies. There are many instances, and I go through some of them in the book, in the chapter, that don't really strike the reader as what seem to be genuine love matches. There are some indications that would show that. There are others that are. Let's see, some of the other sort of things that struck me that you can't really, I didn't put on this chart, is that many of the, and I don't have the exact number, but many of the men that come to the IWL for help, they haven't been arrested. They actually come proactively because, word has kind of traveled through community networks about the kind of positive results that people in their community are seeing. And if they're married, if they feel that they have confident ties to US citizens, they will come forward and actively self-report and adjust their status. I mean, that is really striking. And what we see in these cases is that we get these kinds of outcomes because of, I argue, because of enduring constructions of American citizenship that idealized white heteronormative families with men understood to be the economic and social head of household. So when these men come before the Board of Immigration Appeals, you know, their arguments are really boring after a while. They're very pro forma statements, very rehearsed lines about how their removal would result in economic hardship to their wives and children. And there are many men that have records in their history that would seem as though the Board of Immigration Appeals would rule against them, right? We have cases where immigration law would consider acts of moral turpitude as qualifying you as, not worthy of relief. So, for example, there's one man who shows up. I think he has 3 bigamous marriages and kind of families all up and down the Eastern Seaboard. You have men with criminal records. You have evidence of intent to desert ship. You're supposed to just kind of say like, well, I didn't know this was going to happen. Oh, I missed the boat. Oh, I got this opportunity, so forth. And so what we see is that these things don't really create the negative outcomes that they would in some other immigrants that similarly come in front of the Board of Immigration Appeals. So when we compare the experiences of Italian immigrants to their non-white counterparts, we have situations that are quite different. Scholarship on South Asian and Chinese seamen in this period reveal different outcomes. We see from the scholarship of Heather Lee that when it comes to Chinese sailors, we really see the state curtailing their rights to even disembark off of ships, that there's greater surveillance of Chinese sailors who do get off at ports, that there's more targeted enforcement operations against overstayers in this community. Vivek Bald's scholarship shows that even though South Asian seamen in the early 20th century lived for decades in the United States, married American citizens, fathered American children, deportation rates are much higher for them than the Italians in my sample. And, if we're thinking about the 1950s and targeted enforcement of unauthorized migrants, I think we really all have the example of Operation Wetback coming to mind in 1954, in which the INS is publicizing a very massive military-style operation to raid farms and other employment sites, to crack down on unauthorized Mexican migrants who become, in the American imagination, sort of the quintessential illegal immigrant. I think what we see here sort of contributes to a thread that we see running throughout many of the chapters, that there are kind of parallel systems of immigration that legalize certain groups, normalize the experience of certain immigrants, and not others. So I will stop there.
Oh. All right, while I wait for my slides to pop up here, which I'm confident that they're going to do, I wanted to just take a moment to thank Danielle and Debbie for really being a model of academic generosity in pulling together this volume. And just a personal note, they really made it plausible for me to participate as a new mom when we all gathered together to talk about our chapters, and they kept cajoling me encouraging me, right? And so I just have to say thank you to that. That's really critical and important for making this making our profession like a better place to be. So thank you. Here we go. I have some song lyrics up on my screen here. I hope that you can take a look at those. And I'm just going to start at the end of my story. In the late 1980s and early 1990s, when Congress passed a series of programs that would help legalize the status of unauthorized Irish immigrants, a lot of commentators treated it a little bit like a joke, right? Pork barrel politics at its worst. Some criticized the clear emphasis on white immigration. Others just found the idea of, taking these proactive measures to regularize people's status kind of arbitrary, counterproductive. I obviously saw something different in it. I wrote a whole book about it called Dreamland. And what I wanted to think about when I was writing this chapter for Debbie and Danielle and for I guess the world was that I think it's important to take seriously the fact that the unauthorized Irish who benefited from these series of legislation, they faced the threat of deportation and exploitation like other unauthorized immigrants. So I open my chapter with lyrics from this song that I found in the records of the Irish immigration reform movement. I have no idea how it would be sung, but I found it rather evocative of the experience that many of these young people in New York and Boston and elsewhere in the United States were facing as unauthorized Irish immigrants in the 1980s. The story of how this population achieved relief seems really worth understanding for us, whether as a model for advocates, how others might be protected from deportation in the future, or as a way of understanding why such advocacy is not replicable for other groups. So my chapter is about the Irish immigration reform movement, a grassroots group that formed in the 1980s to advocate for undocumented Irish immigrants, and they were successful. They helped tens of thousands of Irish immigrants succeed at gaining legal status at a time in the 1980s and early 1990s of really pretty intense immigration restriction and criminalization. As Danielle and Debbie write in the introduction, their story points to how the long-standing ascription of legality, belonging, and citizenship to European migrants mediated the experiences of unauthorized Europeans. We could start our story about Irish immigration almost anywhere, but I'm going to point to the 1960s as the launch point for the story of the Irish in my chapter, because of course in that decade, the United States revised its immigration system to emphasize family relationships and skills and to de-emphasize ethnic and national favoritism. Many groups might have benefited from this shift, but the Irish in fact lost access to relative privilege that had existed under the national origins quota system. Also in the 1960s, the Irish economy was expanding, so fewer people were emigrating abroad. The state at home in Ireland was investing in higher education, and so many families were relieved to find that they could plan for their lives without emigration as a central coping strategy. Fast forward to the 1980s, when the economy crashed, right? And all of the promised professional jobs for university-educated Irish people disappeared. Emigration, once again, seemed like a critical survival strategy, but legally immigrating to the United States was no longer an option for many, many people. Because of low post-1965 immigration, few had immediate family members who could sponsor them for visas to become green card holders in the United States. Nevertheless, tens of thousands of Irish people were able to secure short-term visas to the United States, and many then overstayed those visas. The Department of State looking the other way when so many people claim to be coming for vacation at a time of rampant unemployment is likely a reflection of white privilege. Visa denial rates for African countries in the same decade were always much, much higher. Whiteness also likely protected Irish unauthorized immigrants in other ways, helping them blend into established Irish neighborhoods, access ethnic networks to find work, and making them unlikely targets for INS raids. But being undocumented locked people out of access to better jobs, professional jobs that would make better use of their skills. It made people more reticent to put down roots and start families. It empowered unscrupulous employers who were able to exploit them, and it made everyday life precarious and more stressful. And so even at the most mild end of the scale, the threat of deportation looming over people's heads was a horror. And it didn't help that the Immigration Reform and Control Act, passed in 1986, IRCA, directed more resources towards immigration enforcement through new employer sanctions provisions and Border Patrol resources. So a group of these young guys gathered in Woodside, Queens to form the Irish Immigration Reform Movement. They did this in 1987. They then organized chapters up and down the East Coast. They raised money by holding dances. They did advocacy with the Irish embassy, and they also engaged with Irish Americans, community members, as well as Irish American policymakers. They also were really savvy in their use of the media and using the media to tell their story to a broader public. And they felt that publicity would build sympathy for their plight. As a result of this, they were visible. They marched in parades. The media, in their telling of it, really loved them. They loved these sharp, articulate guys with their cute Irish accents and their eloquence. And so the decision to come out of the shadows, right, really benefited them by helping to build sympathy for their condition. When they had that media spotlight on them, right, what did they say? They continually made connections to the history of Irish immigration, painting America as having been indelibly shaped by Irish contributions. These images of the downtrodden Irish immigrant arriving by coffin ship, laboring to provide for his family, lifting himself up, these were operative throughout the debate. And so members of the IIRM were able to evoke historical memory to build sympathy, collapsing past and present through their storytelling. I've always been struck by their success at helping people, the policymakers, the public, recognize the harms that come with immigration restriction and criminalization. That someone like Massachusetts' Brian Donnelly or Ted Kennedy or John Kerry or Bruce Morrison or Chuck Schumer would speak to these guys and come away with the idea, oh, this isn't right, right? Something should be done to help these people get out of that corner that our systems have really backed them into. There were other arguments that went into this debate at the time, how to balance priorities of family unification versus needed skills for the American economy versus humanitarian need. And one of the other strategies that the IIRM took was to help build support for the idea that non-family immigrants should be prioritized. Now, this is actually like super weird of them, right? Because family unity is this core principle of the immigration system, largely because it's seen as really in service of the US citizen. the person who's able to reunite with their family member, not the immigrant. Arguments about the rights of citizens to reunite with their spouses and children had really helped break down the restriction against Asian immigration in the middle of the century with international adoption and war brides and spouses. So family has been really important to unbraiding some of the worst restrictions of the 20th century. That doesn't mean restrictionists have not identified this as a form of nepotism, but it has been very popular for policymakers because it's a system that offloads so much of the work of immigrant integration to individual families, right? It reinforces heteronormativity, obviates the need for the United States to have any kind of robust social safety net, right? Our social safety net is women. But the main reason why the IIRM was successfully able to sort of knock down the primacy of family unity was because of race. By the mid-1980s, 80% of lawful immigrants coming as family members were Asian or Latin American. And so the idea that the United States should prioritize admitting what they called independent immigrants without respect to family ties was able to gain some adherence, right? So throughout these debates, we hear references to the mythic Ellis Island immigrants of the past who had no US sponsors and who nevertheless came, worked hard, and of course succeeded. There he is. There's that guy. The perfect narrative for the go-go 1980s. What this nation needs is strivers, hard workers, bold, independent risk takers who want to succeed on their own talents and merits, who aren't looking for handouts. The mid-century nation of immigrants myth revived for the 1980s. So the IIRM was able to use this narrative while also embodying it. The Ellis Island immigrants were remembered as overwhelmingly European and white, and by telling the story this way, policymakers and the IIRM were able to sort of erase the systems and structures that had enabled Al D'Amato's family to gain a foothold in the middle class, while also obscuring a number of contemporary independent immigrants from Haiti or El Salvador who were being detained by INS at this very moment. They could say something like, we need to create opportunities like those our forebears had without saying this is a white country. They could describe the plight and struggle of the immigrant, their hard work, their determination, without even mentioning race, but because of public memory of this very prominent immigration, people thought continually of white immigrants. The overall volume that my essay is part of here, it's concerned with making race visible in these narratives like the nation of immigrant myths, and in unpacking public memory that still treats the European immigrant as normative. I also think that unpacking these stories helps us understand the limitations of these kinds of arguments that I think advocates do continue to make. When I think about the push for the DREAM Act and other forms of legalization over the last decade or two, there has been this tendency to return to the nation of immigrants story to say, this is who we are, this is what we owe today's immigrants. And it hasn't been particularly effective, thanks not only to the efforts of a very radical and organized nativist movement, but also because of how whiteness works in our public memory of immigration, even while remaining unstated. I have one more slide. An image from this year. This is from May 2025. So during the first Trump administration, and again in the second, here we see news stories of Irish immigrants being rounded up and deported. And these stories frequently generate a lot of public sympathy. The individuals being targeted are often deeply rooted members of their communities. They're married to United States citizens. They have US citizen children. And the public hears the story that ICE has seized them and reacts and responds with outrage, which is how it should be, right? But I wonder why these stories didn't stick in between Trump 1 and Trump 2 when it came time to cast votes in the 2024 election. I think it's plausible to point to the continued erasure of European illegality that continues to this day as a factor there. Many people were convinced that mass deportations now would not apply to them and their loved ones, regardless of country of origin. It's the other side of the same coin as the nation of immigrants myth, wherein the public imagines that good and deserving immigrants are protected and bad and undeserving immigrants are easy to remove. And I think if we can make visible stories uh, about race that are embedded in these kinds of phrases, it might point to more effective advocacy, and one wishes a more inclusive society. Um, and I'll just conclude with the thought that more of us could stand to understand unauthorized immigration not as an exception, but as a constant part of immigration, because as our volume demonstrates, it has been, right? This is a normal, not scary, not problematic uh, thing in need of authoritarian solutions. It's part of the human experience. And I will stop here and hand it over to Torsten.
Okay. It's my pleasure to join you at this nightly hour from Belgium. It's nearly midnight for me, but thanks a lot, Lana, for the platform and hosting us. Thanks a lot, Daniela and Deborah, for the wonderful work you did on the volume. I'm just going to dig in straight to my contribution that zooms in on the role of shipping companies in enforcing and evading US immigration controls during the long 19th century. It is mainly based on the archives of the Holland America Line that managed the passenger service between Rotterdam and New York. Now, these records give a business perspective on migration policies and show how transport companies were integrated as migration governance actors. Next slide, please. It really draws on the theoretical framework from William Walters, who developed the concept via politics, which highlights the importance of transport systems within the migration government studies. Walters is a political scientist who contends that transport vehicles and hubs greatly affect power relations governing human mobility, and that transport companies are pivotal in enforcing them today. Authorities impose this role on transport companies mainly via so-called carrier sanctions. These are fines and penalties for not enforcing certain migration laws on their passengers. The best example that I can give you of today is that airlines still risk heavy fines for flying in passengers without proper identity papers. Now, currently, most measures focus on identity checks. Yet, what are the historical roots of via politics? Now, was it at play during the 19th century, known as the free area of mass migration, when passport laws were actually being abolished? How were shipping lines integrated in the enforcement of US immigration laws on the millions of Europeans arriving between 1819 and 1914? Now, the analysis of their role is divided in three aspects, in three parts. The first one zooms in on the laws on paper, the second one on the enforcement, and the third one on the role of shipping companies to help evade these immigration laws. Next slide. Now, first, I zoom in on the Passenger Acts. That uncovers how federal US authorities try to regulate the crossing and the transport conditions of these migrants in this period. And that actually goes back to 1819. What we see in these passengers already is that shipping companies were explicitly mentioned in the acts, and they were explicitly responsible for enforcing the measures regarding first the passenger capacity, second the hygiene regulations, and third manifesting arriving passengers. Now, arriving with excess passengers, violating hygiene regulations, or incomplete passenger manifests were all liable, made shipping captains and shipping agents of these companies all liable to fines, prison sentences, or even denied entry or departure from American ports. The article zooms in more in depth on the Immigration Act itself, especially when it shifted from a state to a federal jurisdictions from the 1880s onwards. And what we see is that shipping companies were explicitly mentioned in various acts in these laws, and especially throughout the reforms, their role became more prominent. What we see is that, for instance, shipping companies were responsible to circulate US immigration laws among their migrant agents to make sure that migrants and the ones that intended to leave Europe were aware of the immigration laws that were being passed and reforms that were taken. Another important aspect that shipping companies took on were, for instance, collecting the head taxes of all aliens entering the United States, collecting these funds and then transferring them to the American authorities. Now, what they also did is filling out the passenger manifest in logical groups of no more than 30 people, which were used as a cornerstone of US immigration inspection on arrival. Any omission made by shipping companies made them liable to fines of $10. Another section of the acts, for instance, also said that shipping companies had to ensure that all third-class passengers passed immigration inspections. Those who did not were considered as illegal landings and made shipping companies liable to fines of up to even $1,000 and even prison sentences for their shipping agents. Now, they also had to ensure that passengers did not arrive with certain diseases like FAVIS or trachoma, and they risked fines of $100 if they did so. They also were responsible to return all rejected and expelled immigrants at their own costs. So, to conclude, we see that actually shipping companies are very present explicitly in the laws. And then the next slide then zooms in into the second part of the article, where we go and look more closely at the enforcement of the immigration laws. Next slide, please. Now, they also have pointed that these laws, a lot of scholars have pointed that if you look at immigration laws on paper, it actually doesn't tell the whole story. A lot of parts of immigration laws is obscured actually by immigration, by the law. For instance, there's no mention in these laws that I've mentioned, where shipping companies are actually very explicitly mentioned. There's no mentions of differences to apply the laws based on gender, race, is it from Southern or Eastern European to Northern Western European, or on class, for instance. It doesn't mention that first class don't have to pass through immigration inspection. But so if you only look at the laws on paper, you miss a lot of information. But how does that pan out for shipping companies? Does their role go beyond to what the shipping acts say? Is it actually being enforced? Because often these laws, when not enforced, not necessarily have a big impact on the immigration flows itself. And there were some scholars that argued that, for instance, for the passenger acts, the Bureau of Navigation was very lenient and that they were hardly imposed. Whereas the archives of the Holland America Line show that, especially during the 1880s, there was a big crackdown and a strict enforcement of these laws. And we see that shipping companies, especially for arriving with excess passengers, were fined and fined heavily, sending them to courts to try to argue and reduce these fines. And if shipping companies were actually continuing to break these laws, we see that in some cases, the shipping agent was even imprisoned and the sentence was enforced. So we see that in the 1880s that actually there's a big enforcement movement of these passenger acts. And what about the immigration acts? Well, some scholars have argued that the Immigration Bureau lacked funds to properly enforce most of the immigration laws. But again, the archives of the shipping companies tell a different story. They really show through the correspondence with immigration inspectors, especially the heads in the Immigration Bureau, be it the head of Ellis Island or the commissioner in Washington, that they actually often complained about strict enforcement, unclear enforcement, ambiguous enforcement, and continuously changing enforcement, because the law gave a lot of leeway to these immigration inspectors. And what we see is that these shipping companies often go to court to argue their case, that they're not really responsible for certain costs that the immigration authorities are shifting to them, or that they're actually overstepping their jurisdiction to impose things on shipping companies that is outside their jurisdiction. And we see that often shipping companies win these court cases, in other cases, they don't. And the last aspect that I just want to point that laws on paper show only a part. I focus more on what happens in the US. But as Solberg has demonstrated, this has a big impact on remote control, how actually shipping companies elaborated controls to screen passengers before leaving Europe to make sure that these passengers were not being rebuked on arrival. So we see that actually the immigration authorities is quite successful in imposing certain measures on shipping companies, and that they work as obstructors of unauthorized migration. Now, the final section of the paper in the next slide, it really looks at how authorities try to close loopholes and use shipping companies to stem unauthorized entries directly via maritime ports or indirectly via land borders. Now, the analysis exposes the strengths and weaknesses of migration control based on carrier sanctions and how they affect the transfer of power between shippers and government. It shows that shipping companies sometimes spurred loopholes facilitating unauthorized migration and exploited them as a business opportunity, and they generally did so within the legal margins of the law. Yet in some cases, they explicitly violated them. And just to conclude, there are several ways that they actually pushed unauthorized migration, legally so, into advising certain classes of migrants to try and not go through New York where migration controls were stricter, but maybe go to secondary ports to Baltimore, Boston, or Philadelphia. But the most popular one to avoid strict inspections was traveling second class, which was only $10 more than third class, and which was only object to a superficial screening on board. And only a marginal part of these migrants were sent to Ellis Island, but the deportation rates were 10 times less in second class than third class. There's other loopholes and backdoors, fake papers, marriages, especially sailors and stowaways, which connects to Daniela's paper, which has deeper historical roots, and that is discussed there, and where it really discusses how it is difficult for US authorities to prove the desertion of sailors and the involvement of shipping companies, and how it's difficult to actually prosecute people that are in this network. But the weakest link in the whole set of trying to impose immigration controls on shipping companies came when more and more people migrated indirectly via Canada, Mexico, and Cuba, because there all the measures that they tried to impose on shipping companies were to no avail. And when the numbers become really more significant, we see that that's the biggest, weakest spot of the whole system. So just to conclude in the last slide very briefly, is that we see that shipping companies have like a paradoxical role where they actually help obstructing unauthorized migration. So next time, if you see like these pictures of Ellis Island where immigrant inspectors control passenger manifests and check them with the migrants before them, don't forget the shipping companies that actually brought them in, because they play a very important role in this whole process. And this case study shows that via politics was actually a lot more elaborate than it is today. And it would be very interesting to move beyond and to look how it unfolded more into the 20th century. And I'll just leave it at that. Thank you very much.
Thank you so much. We have a few minutes left for Q&A, so please, if you haven't already, put your question into the Q&A function on the chat. And while people add their questions there, I'm going to take moderator privilege and ask one of my own. And a few of you have touched on this already, but I would love to hear folks talk a little bit more about how you think this monumental work, the volume as a whole, reframes our public conversations about immigration, because we have this narrative, this pernicious narrative that circulates still, that contrasts contemporary immigrants with presumably older, older and better European immigrants who presumably came legally and were hardworking. And really, European immigration is held up as the standard to which other global South immigrants today are falling short. And I think that your work really upends that paradigm. It makes that paradigm kind of impossible to sustain in so many ways, not only because it shows us that unauthorized European immigrants were present throughout, at least from what we've seen, the entire 20th and part of the 19th century. And of course they were, because restrictions produce illegality, that as soon as you have immigration restrictions, you will have people who have defied those restrictions to be here. But also, not only that they were present, but also that so many European immigrants who were unauthorized managed to legalize their status, managed to gain access to legal status and then citizenship because of the sympathy that they engendered from politicians and authorities, right? A sympathy, this idea that, oh, it's not that we've broken the law, it's that the system is unfair. That is something that actually, as immigration historians, we know to be true. It's something that immigrant rights movements have been saying for generations, and yet it's something that is so often falls on deaf ears, except somehow when these unauthorized European immigrants say it, and then it is taken seriously and made into law, made into policy, presumably because their whiteness makes them sympathetic characters. So yeah, I would just love, I know we don't have a lot of time, but I would love if any of you wanted to reflect on how you think this book is upending those false narratives, those false dichotomies of good immigrants and bad immigrants that we have circulating in our political discourse.
Well, whether or not it breaks into the political discourse, I think a lot of us stopped predicting in 2016, right? But I'll say that, Lana, I think your comments at the beginning of the webinar about recognizing how our field intersects with settler colonialism is something that Debbie and I paid a lot of attention to in the introduction. And I think scholarship like yours, work that Samantha Seeley has recently produced, is making us grapple a bit more with the narrative of my relatives came in the right way. I mean, there was no wrong way for a lot of these people until 1924. It was only others, right? African Americans or African peoples, Native peoples, whose rights of movement were heavily restricted until the early 20th century. And so, whether or not that breaks through into the public discourse, I don't know. Does anyone else want to comment on that?
Yes, I don't know who's listening to us and if they have any power to update the Registry Act. But I think, the stories that we tell in the volume speak to the fact that these are choices, right? That illegalization is a process, and that when we can tell stories about histories of legalization, it actually seems quite simple, right? Update the date of the Registry Act, allow people to adjust their status, that sort of non-scrutiny of people's marriages. In your data set, Danielle, maybe they were in love, maybe they're not. Like, why is it our business, right? Like, it's possible to do this sort of thing and have a lot of people avail themselves of relief, and the sky doesn't fall, right? And in fact, I think much of the public assumes that these routes of regularization of status are easily accessible to people. So I mean, I will continue to be loud and bang my head against all the available walls, and that's sort of my plan for contending with this. But I do think that historicizing it and seeing like the very good work that you've put together helps us understand just sort of like the depths of these continuities and opens up, possibilities for us to imagine different ways, right? The future is a fairer future is not one in which the Irish are deported as often as Salvadorans, right? It's one in which everybody has access to relief and is able to live their lives, right? So that's my 2 cents. I'm very blunt about it, and I can't hide it at all. But that's sort of my feeling these days.
Yeah, thank you. Really well said. That we are at time, but we have so many great questions. So I apologize to everyone in the audience who did not get their question in. I really encourage you to please reach out to these authors if you have a question that didn't get answered here today, or if you want to know more about their work. I really encourage you to get a copy and read from your local library of Hidden Histories of Unauthorized Migration. It's really a stunning book that I think, particularly for immigration historians, is going to change the way that we tell these histories, change the way that we write these histories. So I want to thank all of our panelists today for their brilliant work, and thank you for this book, and thanks everyone for listening. And I hope I'll see you all next time.